The Chamber can also quote 92 Quarter witness Mujo Jafic, who states in paragraph 31 of his prior statement admitted on exhibit number P840 that a short while before the end of the war, Vasquez and his men looted all the companies in Iliash by taking away building materials, which they then loaded on lorries. The witness saw Vasquez taking charge of a lorry which was filled with stolen goods. Fifth point. Count 1. Persecution on political, racial, or religious grounds. The Chamber refers inter alia to all the aforementioned evidence regarding the other counts mentioned in the indictment that constitute some of the underlying acts of prosecution committed on religious and political grounds with the participation of the accused. It is therefore not necessary to provide further evidence that the Chamber has relating to this count that enable us to establish a nexus between instigation and this crime. Accordingly, the Chamber feels that there is sufficient evidence for a reasonable trier of fact to conclude at this stage that there is a substantial nexus between the acts of instigations by the accused and the crimes committed. Conclusion. In light of the review of the evidence on the commission of crimes, on the participation of the accused in such a commission, through instigating acts, and on the nexus between the crimes and the instigating acts of the accused, the Chamber holds that there is sufficient evidence at this stage to meet the requirements of Rule 98 bis of the rules for a reasonable trier of fact to convict the accused beyond all reasonable doubt for having instigated the commission of all the crimes alleged in the 9 counts of the indictment. The Chamber, in its majority, Judge Antonetti dissenting, wishes to recall that this conclusion does not require the Chamber at this stage to review all other forms of responsibility alleged in the indictment, namely the physical commission, specifically persecution, expulsion, and deportation and forcible transfers, participation in joint criminal enterprise, and the other forms of responsibility as provided for in Article 7, paragraph 1 of the statute. For the foregoing reasons and pursuant to Rule 98 bis of the rules, the Chamber dismisses the accused's motion. Since I do not agree with part of the majority decision, I must state my position orally. In light of the issues that will be raised, while I read out my text, I shall use charts which will be displayed at my request on the various screens. I would like to thank the registrar and the usher in advance for their assistance.
Interpreter's correction, read out instead of redact. With regard to the method I have used, to reach these conclusions, which are my personal conclusions, I want to first and foremost express my thanks to our intern and to my legal assistant who made it possible to prepare the charge that is soon to be presented. It was a lot of work because they had to go through thousands of documents and tens of thousands of pages to do so. It was a major piece of work. A major undertaking. And I wanted to thank them for this. In order to assess the prosecution evidence, first of all, by way of introduction, I wish to say that I relied mainly on an exhibit that I feel is very important, that was tendered into evidence by the OTP, that is now part of the case file, and that relates to all the interviews or transcripts of the accused in the Milosevic proceedings. It went over several days, and it is several hundreds of pages long. So this was one of the foundations on which I relied. Equally, I read and scrutinized each and every decision by trial chambers and appeals chambers in relation to the events that occurred in the former Yugoslavia. And these are res judicata. These are of common notice, and I may state some of them in my dissenting opinion. And apart from the documents, I also read motions and public decisions in cases that were relevant to the matters at issue in this case. When I finish reading my partly dissenting opinion, which is 73 pages long, I'll give to Mr. Markussen and Mr. Šešelj the document I'm about to read out. Together with attached charts and tables listing witnesses and exhibits so that they can find their way around, as it were. First of all, I have structure, a plan. Mr. Usher, please display it on the Elmo. It has been translated into English and into the accused's language.
Alors, on voit ceci donc en anglais.
So you can see this in English. I will have some preliminary remarks. Then the 98 bis proceedings in relation to acquittal. Third chapter, the crimes alleged in the indictment, allegedly committed in Croatia, in Bosnia and Herzegovina, and in Serbia. Fourth chapter, individual criminal responsibility as to planning, ordering, instigating, committing under JCE 1, 2, and 3. Crimes of persecutions, crimes of deportation and of forcible transfer, aiding and abetting under number 5. And finally, the charges, with 2 overall charts summing up the counts, which in my view should give rise to acquittal in part of the accused, and summing up the counts that for which the trial proceedings should be continued. I have a few minutes left before the break, and I'll start with Chapter 1, or rather with preliminary remarks. Review of prosecution evidence further to Rule 98 bis is to be seen here in a very specific context compared with other cases brought before this tribunal. First of all, the pre-trial custody is really out of the ordinary. The accused was detained on the 21st of February 2003. This pre-trial and trial custody has lasted more than 8 years, way beyond the standards set up by the European Court of Human Rights, and it may only be extended for relevant and sufficient grounds, such as the complexity of the case, the need to maintain the accused at the disposal of justice, the need to prevent reoffending, see on this point European Court of Human Rights, 29th of October 2009, the Paradis versus France case. Another reason may be the issue of pressure exerted on witness. In this regard, refer to the European Court of Human Rights, 10th of March 2009, Bykov versus Russia. Secondly, there have been several ongoing allegations that result from the unlawful disclosure of the names of protected witnesses or from pressure exerted on witnesses. The possible impact of such allegations on the indictment would, in my view, anyway, non-existent, because pressure or disclosure of names of protected witnesses did not occur before the indictment was drafted. The indictment was therefore not contaminated by this type of pressure or violation, if any. Thirdly, There are ongoing contempt proceedings against several OTP members. In my view, such proceedings, in which we can only expect the conclusions of the amicus curiae at best in October 2011, may have a direct impact on the indictment. In the event that witness interviews would have been vitiated, invalidated by such pressure exerted on them. Since an indictment is based on interviews, witness interviews that gave rise to witness statements that are then admitted into evidence. You have, for instance, the statements of witness VS009 of 12 February 2003 and 16th of June 2006, but it relies also on documents. Therefore, there may be an impact such as to carry out the total or partial nullity of the indictment. Therefore, I believe at my own level that in any event, it would be better to wait until October before we can usefully start the second made stage of the proceedings further to Rule 73. Should the amicus curiae conclude that there was no contempt of court, should he exonerate the OTP, the defense case could then commence. Conversely, no defense case can begin before the total or partial cleansing of the indictment, be it on application of the prosecution, further to Rule 51, in relation to the withdrawal of an indictment, or at the request of the accused, further to Rule 73. In the latter case, the accused could seize the chamber for a decision to be issued or to obtain reparation of the damage suffered. Furthermore, this would be a first in this tribunal, and since such a case was never envisioned by the rules, I am of the view that the trial chamber, proprio motu, failing motions bar the parties and further to Rule 85A, could decide that all the evidence has been adduced and start the end of the proceedings as per Rule 86.
I am absolutely opposed to this request by the prosecutor because I never ever filed a confidential submission. I filed a public motion and it can be seen on my website, and it was also published in one of my books. So it can under no circumstances be a confidential motion. It is me who decides whether my motions are confidential or public, and I'm fully opposed to this manipulation by Mr. Markussen.
The trial chamber will see whether there's a need for reduction or not. Whatever the case may be, let me say that at this stage of the proceedings, it is not necessary to look into whether there was one or several cases of perjury. as far as I can see, it's only at the time of the final deliberation that this issue will have to be settled in a final way. In this respect, I must remind you of a very recent decision of the Appeals Chamber dated 1st of April 2011 in the case Tarsis Renzau. Paragraph 196. It says that the defense must prove that the damage suffered is tantamount to an error of law invalidating the judgment. Well, the President has not ruled yet on the new submission, so we have to wait for his decision. This submission does not bear any direct bearing, be it direct or indirect, on the development of the 98 bis proceedings. It would be a totally different kettle of fish if we were at the level of the final deliberations. Finally, this case is to be seen in a very specific context, inasmuch as we have two judges of the bench who also sit in trial chambers seized of identical facts for certain crimes or of the same joint criminal enterprise. In these other cases, there are various prosecution expert witnesses or witnesses who may have testified in the three cases, or at least two of them, before the same judges. Each testimony has to be ascertained as to their relevance and probative value at the moment of the final deliberations. Taking into account the fact that the three trials in question are not at the same level of progress, it may be that one judge may assess the testimony of a given witness in a specific way in one trial, and then he will have to assess the same testimony, but several months later in another case, without any new element. So is he or she going to give the same probative value, the same weight? The fact that several judges may participate in several trial proceedings where you hear the same witnesses, this has been dealt with in the Tarsis Renzau case with regard to the second ground of appeal. I think it's interesting enough for me to mention it. And the appeals chamber ruled in paragraphs 22 and 23 in the following way. A presumption of impartiality is granted to the judge in the absence of any contrary evidence, thus dismissing the defense argument that the same judges had taken part in other trial proceedings on the same facts with the same witnesses, and this would have been a violation of the presumption of innocence. At this stage, notwithstanding the above-mentioned appeals decision, I cannot assess what the direct consequences would be on this case of the fact that my colleagues are part of other cases. This can only be done at the time of the final deliberations, and it might be interesting to hear the parties on this. So much so that I think we have to point out something that must have escaped the prosecution, namely that in the indictment against Šešelj, the joint criminal enterprise is alleged to end in September 1993, mentioning among the participants Karadzic, whilst in the indictment against Karadzic, Šešelj is alleged to be a participant, but the joint criminal enterprise is ongoing from October 1991 to the 30th of November 1995. There is therefore an obvious contradiction that puts the judge sitting in the two cases in a particularly difficult situation to assess the scope, the extent of the JCE. To get out of this dilemma, one would have to wait until the three trials are completed if we want to avoid running this type of risk. The completion strategy of this tribunal doesn't make it possible to extend trial proceedings forever. all the more so since the accused has been in custody for too long already. Therefore, I was bound out of principle to raise this theoretical issue at this stage of the proceedings, while saying, much to my regret, that this trial should be completed as quickly as possible, whilst the very implementation of specific inescapable legal constraints should be such that we have to wait until the Karadzic and Stanisic Juplenian proceedings are completed to have our final deliberations, which should be postponed sine die. So we're going to wait, but there maybe should be a discussion on the redaction.
Alors, la majorité
The majority opinion, me dissenting, decided to redact the part as suggested by Mr. Markussen.
Znači li to da je gospodin Markussen
Does this mean that Mr. Markussen has just declared my motion a confidential one and that the majority of the chamber accepted that? Your Honors, did you declare this motion of mine to be confidential? And are you entitled to do that? You're not. And this is an abuse of your judicial role.
l'affaire a été.
Well, the matter is settled. We're going to adjourn. Or rather, we'll have a 90-minute break. We shall resume.
Le quart et une demi-heure. Donc, on va reprendre aux environs de.
We shall resume.
De 3h15.
We shall resume around 3:15.
All right, we will leave.